ISA. This is really a simple case in my mind. When Congress asks you a question, you're expected to give a truthful answer. And when Congress issues a subpoena, compliance is not optional. Imagine if a taxpayer failed to comply with an IRS summons or subpoena. What would they do to you? If they ask you for those materials, you're expected to produce those materials. And if you don't, they're going to take you to court and they're probably going to win. The IRS targeting scandal was un-American. The IRS is the most powerful and feared entity in the United States. The First Amendment rights of citizens were trampled upon. Now, in fairness, Mr. Koskinen, as the commissioner of the IRS, was not there for the initial targeting. He was brought in by President Obama as a turnaround artist, somebody who would work hand in hand with Congress to fix the problem. From my perspective, he didn't fix the problem, he made it worse. There have been numerous hearings, letters, and subpoenas issued by a variety of committees. Now, and I think we must stand up for ourselves. Now, give some background. I'm going to show a video. It's about 10 minutes, and then we'll get into the very specifics of where I think Mr. Koskinen lied.
From the woman at the center of the IRS
scandal involving IRS targeting of conservative groups.
Where's Lois Lerner?
Lois Lerner. Targeting conservative groups.
Lois Lerner.
That's when Lois Lerner's... This was orchestrated, it was planned.
The possibility of criminal activity.
The whole truth and nothing but the truth. Let the record indicate that the witness did answer in the affirmative.
On the advice of my counsel, I respectfully exercise my Fifth Amendment right and decline to answer that question.
The IRS and Lois Lerner, something we've only received over the years in bits and pieces. But what does it look like all pieced together? Let's rewind. In 2013, the IRS admitted to the selective intentional targeting of American taxpayers based on their political beliefs. This is Lois Lerner. She was the IRS employee with the most knowledge of the intentional targeting, but when called to testify, she refused. With the key witness unwilling to cooperate, to get to the truth, Congress had to obtain and review documents. What followed was a sequence of obfuscation, obstruction, and destruction of evidence by the IRS, which has left the American people with no real answers to why their First Amendment rights were violated. With rumors of targeting percolating, in June 2011, Ways and Means Chairman Dave Camp sends the first letter to the IRS related to the allegations of the IRS's mistreatment of conservative groups. 9 months later, in March 2012, Chairman Darrell Issa and Jim Jordan of the House Oversight Committee send a letter to the IRS requesting information. By May 2013, the IRS admits to targeting, and Chairman Issa and Jordan send yet another letter to the IRS requesting information. The President acknowledges wrongdoing and pledges cooperation.
It's inexcusable, and Americans are right to be angry about it. Our administration has to make sure that we are working hand in hand with Congress to get this thing fixed.
By August, the Oversight Committee issues its first subpoena, and the committee sends a letter to the Treasury Secretary reminding him of the obligation to preserve all emails. At this point, 3 congressional committees, the Inspector General, and the DOJ all have investigations underway. Fast forward 9 months. After he condemned the targeting, President Obama states in a February 2014 interview that there is not a smidgen of corruption.
Not even mass corruption, not even a smidgen of corruption.
But all these investigations are still open. Even the investigation he ordered was not complete. So how did the president arrive at this conclusion? What did he become aware of in those 9 months? Meanwhile, IRS Commissioner Koskinen appears before multiple congressional panels, promising to deliver all of Lois Lerner's emails.
Are you going to provide the documents for Lois Lerner?
Yes.
That were subpoenaed?
Yes. We're working very hard to get you the Lois Lerner emails.
Are you or are you not going to provide this committee all of Lois Lerner's emails?
We are already starting that
or...
process. Yes, we will do that.
Until he starts backtracking and obfuscating and parsing.
Process. We'll redact them. There's going to be thousands of pages, but it's not going to expedite the conclusion of this investigation.
And then, in June 2014, he tells Congress that Lerner's emails could not be recovered.
As the actual hard drive, after it was determined that it was dysfunctional and that with experts no emails could be retrieved, was recycled and destroyed in the normal process. This was...
So was it physically destroyed?
That's my understanding.
So what could have possibly happened for the commissioner to make such a statement? Remember that very first letter from Chairman Camp to the IRS in June 2011? Well, coincidentally, Lois Lerner's hard drive crashes just 8 days later. What are the odds? Her hard drive crashing within a week of an inquiry from Congress truly defies all odds. This hard drive will sit in a bin for nearly 8 months, until it is destroyed, within weeks of an IRS internal investigation commencing. Another coincidence. In April 2013, a month before admitting to the targeting, Lois Lerner reminds colleagues to be cautious about what we say in emails. And on that same day, asks whether the internal instant messaging system is archived. When told no, Lerner responds, "Perfect." So back to May 2013. The IRS just admitted to targeting and the president just promised cooperation. Lois Lerner comes before Congress and takes the fifth. And on the exact same day, nearly 2 years after Congress started asking questions, the IRS finally issues a non-destruct order to all IRS personnel. So with an admission of targeting, subpoenas, and investigations underway, we return to the president's peculiar comments from February 2014.
Not even a smidgen of corruption.
Well, on the same day the president makes those comments, the IRS discovers a problem, a gap in Lois Lerner's emails. Thousands of emails are missing from around the critical period in the targeting in 2011. Remember, her hard drive crashed. Staff recognizes the need to collect backup tapes that might contain emails from the relevant time frame. Good thing for that non-destruct order and the subpoena from Congress ordering the preservation of documents. But on March 4th, 2014, 422 backup tapes containing emails from the relevant time frame are destroyed. This is 30 days after realizing there's a gap and 8 months after the non-destruct order. And the subpoena. How does something like this happen? The IG testifies that it's truly an unbelievable set of circumstances.
How in the world, with the preservation order and a subpoena, do they destroy 422 tapes?
It's an unbelievable set of circumstances that would allow that to happen.
And wasn't Commissioner Koskinen appearing before Congress at this same time, assuring members that the IRS would turn over all emails? Did the commissioner intentionally mislead Congress? Testimony suggests that the IRS knew that Lois Lerner's emails had been destroyed at the time of the commissioner's March testimony. Remember all the open investigations. Besides Congress and the DOJ, the IG was also investigating varying aspects of the targeting scandal. They started looking into Lois Lerner's emails in June 2014. Here's their story. In June 2014, the IG opens its investigations into the missing Lois Lerner emails. Commissioner Koskinen confirms that Lois Lerner's emails cannot be recovered and describes the great lengths the IRS has gone trying to find them.
We've spent, as I noted, at last count, $18 million responding. We've had over 250 employees at various times involved. We've had over 100 or 120,000 hours of effort devoted to it. And as I said, we've gone to great lengths. We've retraced the process for producing her email twice just to make sure that no email was missing. We understand the importance of this investigation. We've gone to great lengths, spent a significant amount of money trying to make sure that there is no email that is required that has not been produced.
They didn't find any. Meanwhile, the IG is looking for backup tapes. Just 15 days into their investigation, the IG drives 1.5 hours from D.C. to an IRS facility in West Virginia and asks for backup tapes used to back up Lois Lerner's email account. They are handed 744 tapes.
It's identified the 744 backup tapes that met this criterion, and TIGTA took possession of all of the identified 744 backup tapes.
Attendants at the facility said no one ever asked them for the tapes, but that they've been there all along.
IRS in testimony and letters stated that it left, and I quote, "no stone unturned," end quote, to recover the emails. Was that true?
And we were able to recover emails. So it would appear that that statement is
that
a relative
statement was
statement.
not true. July 2014, IRS officials testified that it, quote, confirmed the emails were unrecoverable, end quote. Given that recoverable data still existed on the tapes, was that statement true?
It would not appear to be true.
It would not appear to be true. And I quote, "no way," end quote, to recover them. Was that true?
That would not appear to be true.
That would not appear to be true. We have established here today multiple incidents where the IRS did not tell the truth.
Throughout the course of their investigation, which went into the summer of 2015, the IG recovers 1,000 unique emails that were never turned over by the IRS.
But what did they do with these emails?
To the best we can determine through the investigation, They just simply didn't look for those. So for the over 1,000 emails that we found on the backup tapes, we found them because we looked for them.
They had them. They were under subpoena. What a coincidence.
Remember those 422 tapes that were destroyed after the IRS knew they were missing emails? And after the non-destruct order was in place? And 8 months after the subpoena? If those had been properly preserved, an additional 24,000 emails may have been recovered, and maybe there would be answers. But the American people will never know, because the IRS didn't do its job of preserving the information the way it was obligated to do. The IG also concluded in its investigation that the IRS neglected to search sources beyond Lois Lerner's hard drive for emails.
How many potential sources for recovering Ms. Lerner's emails existed for the IRS?
We believe there were 6. The hard drive would have been a source, BlackBerry, backup tapes, server drives, the backup tapes for the server drives, and then finally the loaner laptops.
How many of these 6 did the IRS search?
We're not aware that they searched anyone in particular.
They didn't look for backup tapes. They didn't look at her BlackBerry. They didn't look at the server, or backup server, or the loaner laptop. So what great lengths did they really go to?
On the advice of my counsel, I respectfully exercise my Fifth Amendment right and decline to answer that question.
The bottom line, IRS didn't fulfill its legal obligation to respond to Congress. They didn't preserve information. They didn't try to find the information. They misled Congress for years. Their failings leave the American people in the dark about how their First Amendment rights were trampled upon. There must be accountability.
Mr. Chairman, thank you for allowing us to show that video. I want to drill down a little bit further on Mr. Koskinen's testimony to Congress, especially some of the statements made to Congress in June and July of the year 2014, when he came to explain why the IRS wouldn't be able to produce thousands of Lois Lerner's emails. At that point, a subpoena had been in place since August of 2013. The subpoena was reissued to Mr. Koskinen after he was confirmed, so by then the subpoena had his name on it for more than 5 months. On February 2nd, 2014, Super Bowl Sunday, Kate Duvall realized that there was a problem with Ms. Lerner's emails and that some of them were missing from the IRS production to Congress. Ms. Duvall was counsel to the commissioner at the time, and she was basically managing the IRS production to Congress. The next day, on February 3rd, Ms. Duvall told her colleagues at the IRS about the problem she had found. She told the IT people. She talked to the people in the Office of Chief Counsel. She talked to the Deputy Associate Chief Counsel, Thomas Kane. And by the next day, February 4th, Thomas Kane had figured out that Lois Lerner's hard drive had crashed back in 2011, and that was why many of her emails were missing. So the IRS knew in early February that there was a problem with Ms. Lerner's emails. And Mr. Koskinen testified that he knew in February. This is his quote on a July 23, 2014 hearing. Quote, "What I was advised and knew in February was that when you look at the emails that had already been provided to the committee and other investigations, and instead of looking them by search terms, looked at them by date, it was clear that there were fewer emails in the period through 2011 and subsequently. And there was also, I was told, there had been a problem with Ms. Lerner's computer." So the question is, what did Mr. Koskinen, under subpoena, do about it? After all, he had this subpoena. He had just learned that most crucial evidence covered by the subpoena was missing, and so you'd expect him to spring into action. Well, let's start with what he did not do. According to the Treasury Inspector General for Tax Administration, he failed to look in 5 of the 6 places Ms. Lerner's emails could have existed: the backup tapes, her BlackBerry, the server, the backup server, and the loaner laptop. In fact, the IRS barely looked for this missing emails at all, according to TIGTA. Now let's talk about what Mr. Koskinen did do. In April, his agency notified the Treasury Department and the White House that Ms. Lerner's emails were missing. And then he waited. And then he waited some more until June, when the IRS finally told Congress by burying a couple of sentences in the 5th page of an attachment in a letter to the Senate Finance Committee. That was on June 13th, 2014. That triggered a flurry of hearings in Congress, and Mr. Koskinen came up to testify to explain what he said. And then he lied. We've got 3 quotes here I want to share with you, among many. But let's look at what he told us on June 20th in 2014. 7 days after finally telling Congress that Ms. Lerner's emails were missing, he said, Since the start of the investigation, every email has been preserved. Nothing has been lost. Nothing has been destroyed. That's not true. The investigation began in May of 2012. The Inspector General found the IRS destroyed evidence, 422 backup tapes that contained as many as 24,000 emails to and from Ms. Lerner, and that happened on March 4th of 2014.
The President acknowledges wrongdoing and pledges cooperation.
It's inexcusable, and Americans are right to be angry about it. Our administration has to make sure that we are working hand in hand with Congress to get this thing.
On everything I've seen, quoting Mr. Cummings, the case is solved. This is regarding the IRS scandal.
Which case?
The IRS scandal.
The IRS case?
Yeah.
You know, the IRS case is currently under investigation, and basically it's just started.
Yeah. What can you tell us? I mean, you started a month ago. What can you tell us about this? Have you found Have you found the now infamous 2 rogue agents? Have you discovered who those people are?
Needless to say, because it's under investigation, I can't give out any of the
Can you tell me some basics? Can you tell me how many agents, investigators you've assigned to the case?
May be able to do that, but I'd have to get back to you.
Can you tell me who the lead investigator is?
Off the top of my head, no.
This is the most important issue in front of the country the last 6 weeks. You don't know who's heading up the case? Who the lead investigator is?
At this juncture, no, I do not know who the.
Can you get that information to us? We'd like to know. We'd like to know how many people you've assigned to look into this situation.
I have not had a recent briefing on it. I had a briefing on it when we first initiated it, but I have not had a recent briefing as to where we are.
So you don't know who's leading the case?
I do not know who is the lead agent.
Do you know if you've talked to any of the victims? Have you talked to any of the groups who were targeted by their government? Have you met with any of the Tea Party folks since May 14th, 2013?
I don't know what the status of the interviews are by the team that's on it.
This committee has had substantial focus also on the practice of the previous IRS of targeting citizens and citizen groups based on their political speech, political views, and perceived political opposition to President Obama. And the previous Department of Justice, both Attorneys General Holder and Lynch, in my view, stonewalled that investigation. Is the FBI currently investigating the the IRS's unlawful targeting of citizens for exercising political speech?
I think you're referring to the investigation focusing on particularly groups allegedly associated with Tea Party.
Yes.
We completed that investigation and the department declined prosecution. We worked very hard on it, but a lot of people on it couldn't make what we thought was a case, and to my knowledge, it has not been reopened.
Interview that there is not a smidgen of corruption.
Not even mass corruption, not even a smidgen of corruption.
Gordon for 5 minutes.
Did the FBI pay Christopher Steele, and was the dossier the basis for securing warrants at the FISA court to spy on Americans associated with the Trump campaign? Really, when you sum it all up, it boils down to those fundamental questions. Did you pay the guy who wrote it? And did you use what he wrote, disproven, discredited dossier paid for by the Clinton campaign? Did you use it to go get warrants to spy on Americans? That's what it comes down to. And you're the guy who can answer those questions. And yesterday I was convinced that the answer to those questions was probably yes. But today I'm even more convinced the answer is yes, based on the text messages we got to read early this morning. Mr. Rosenstein, you know Peter Strzok? You familiar with that name?
Yes, I'm familiar with the name. And
former deputy head of counterintelligence at the FBI? Peter Strzok, that one?
I don't know his precise title, but yes, he had a significant role in.
Peter Strzok ran the Clinton campaign, interviewed Mills, Abedin Clinton, changed the exoneration letter from gross negligence to extreme carelessness. Peter Strzok, who ran the Russian investigation, interviewed Mike Flynn. Peter Strzok selected by Mr. Mueller to be on his team. That Peter Strzok, we learned, had all these text messages. We got to read some of them early this morning. Now, as my colleagues have pointed out, some of them are, they show he didn't like Trump. He and Miss Page are exchanging text messages back and forth, show they don't like the president. But that's nothing new. Everyone on Mueller's team, no one on Mueller's team likes Trump. We already knew that. But I want to focus on one in particular. One in particular. And this is a text message from Mr. Strzok to Miss Page, recalling a conversation and a meeting that took place in Andrew McCabe's office, Deputy Director of the FBI, recalling a meeting earlier. And Mr. Strzok says this: I want to believe the path you threw out for consideration in Andy's office. Then there's a break. Dash, it says that there's no way he gets elected. No way Trump gets elected. He says, I want to believe that. You said that in the meeting in Andrew McCabe's office. I want to believe that. But then he goes, but I'm afraid we can't take that risk. Now, this goes to intent. He says, we can't take the risk. The people of this great country might elect Donald Trump president. We can't take this risk. This is Peter Strzok, head of counterintelligence at the FBI. This is Peter Strzok, who I think had a hand in that dossier that was all dressed up and taken to the FISA court. He's saying we can't take the risk. We have to do something about it. Now, don't forget the timeline here either, Mr. Rosenstein. Peter Strzok, January 10th, he's the guy who changes the exoneration letter from gross negligence, criminal standard, to extreme carelessness. July 2nd, he's the guy who sets in on the Clinton interview. July 5th, 2016, that's when Comey has the press conference and says, we're not going to prosecute. Clinton's okay, we're not going to prosecute. And then August 2016, we have this text message. The same month that the Russian investigation is opened at the FBI, August 2016. And my guess is that's the same month that the application was taken to the FISA court to get the warrants to spy on Americans. Using this dossier that the Clinton campaign paid for, Democrats paid for, fake news, all dressed up, taken to the court. So I got really just a couple basic questions. Because it seems to me if the answer to any of those two questions, if the answer is yes, if you guys paid Christopher Steele at the same time the Democrats in the Clinton campaign were paying, or if you took the dossier, dressed it all up, took it to the FISA court, and used that as the basis to get warrants, and now we have intent in this text message saying that there's another text message, my colleague referenced it earlier, where Mr. Strzok says, I can protect our country at many levels. Says it with all the humility he could muster. I can protect our country at many levels. This guy thought he was Super Agent James Bond at the FBI. This is obvious. I'm afraid we can't take that risk. There's no way we can let the American people make Donald Trump the next president. I got to protect our country. This is unbelievable. And I'm here to tell you, Mr. Rosenstein, I think the public trust in this whole thing is gone. So it seems to me you got two things you can do. You're the guy in charge. You're the guy who picked Mueller. You're the guy who wrote the memo saying why he needed to fire Comey. You're the guy in charge. You could disband the Mueller special prosecutor, and you can do what we've all called for. Appoint a second special counsel to look into this, to look into Peter Strzok, Bruce Orr, everything else we've learned in the last several weeks.
Yes, Congressman, and I can assure you that I consider it very important to make sure the thorough review is done, and our Inspector General is doing a thorough review. That's how we found those text messages as part of that review.
You've given that answer like 15 times. Let me ask you this. Are you concerned? I mean, this is what a lot of Americans are believing right now, and I certainly do, that the Comey FBI and the Obama Justice Department worked with one campaign to go after the other campaign. That's what everything points to. Think about what we've learned in the last several weeks. We first learned they paid for the dossier. Then we learned about Peter Strzok. And last week we learned about Bruce Orr and his wife, Nellie. I mean, this is unbelievable. So what's it going to take to get a second special counsel to answer these questions and find out, was Peter Strzok really up to what I think he was?
I think it's important to understand, Congressman, we have an Inspector General who has 500 employees and a $100 million budget. And this is what he does. He investigates allegations of misconduct involving department employees. That review that he is conducting is what turned up those text messages. It will also involve interviews of those persons and of other witnesses.
And we're looking forward to his report, and we've met with Mr. Horowitz, and we're anxiously awaiting that report.
I yield back.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Director, in your opening comments, you said this was an unusual case. I would say that's the understatement of the year. Husband of the subject meets with the Attorney General 3 days before Secretary Clinton is interviewed by the FBI. 9 people get to sit in with Secretary Clinton during that interview. One of those was her Chief of Staff, Cheryl Mills, who was the subject of the investigation. 5 people get some kind of immunity. 5 people get some kind of immunity, yet no one is prosecuted. 3 of those people who get immunity take the 5th in front of Congress, and one of them doesn't even bother to show up when he's subpoenaed supposed to have been at that very chair you're sitting at. And of course, the Attorney General announces that she's going to follow your recommendations, even though she doesn't know what those recommendations are, the only time she's ever done that. So of course this was unusual. We've never seen anything like this, which sort of brings me to the post. I'd like to put up the post that some have talked about, which is the post by Mr. Combetta on Reddit. And you said earlier that you don't know if you examined this during your investigation, so let's examine it now. I need to strip out a VIP's address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Now, Director, when I hear the term strip out email address, I think of somebody's trying to hide something, somebody's trying to cover up something, and it sort of raises an important question from these two sentences. Who's the they who wants something hid, and who's the VIP who also wants something hid? Director Comey, is it likely the VIP well, actually not just a VIP, it's a very, very important person according to Mr. Combetta. Is it likely that that person is Secretary Clinton?
Yes, sure.
Okay, and is it also likely that the they refers to her Secretary Clinton's staff and specifically Cheryl Mills?
I don't know that. Either her lawyers or some staff that had tasked him with the production.
So one other thing that's important on that, if we could put that back up, one other thing that's important is the date. The date at the top says July 24th, 2014. So whenever I see a date, I'm sure you do the same thing, I always look at what's happening about that same time frame, what may have happened directly before that, and maybe directly after that. So I went back to your reports that you guys had given to us. The first report back last month, August 18th, 2016, page 15. On page 15 it says, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. State Department gives Cheryl Mills a heads up that she's got to go round up all of Secretary Clinton's email. On that same page it says the House Select Committee on Benghazi had reached an agreement with the State Department regarding production of documents on July 23rd, 2014, just the day before, which I find kind of interesting. Then from your report that we got just last week, after reviewing several documents dated in and around July 23rd, 2014, Paul Combetta had a conversation with Cheryl Mills, and after reviewing a July 24th, there's that date again, 2014 email from Brian Pagliano, Paul Combetta explained Cheryl Mills was concerned Clinton's then current email address would be disclosed publicly. So, sure looks to me like it's Secretary Clinton, as you said, but also that it's Cheryl Mills and Brian Pagliano who are urging Mr. Combetta to cover this stuff up. You agree?
From what you read, it sure sounds like they're trying to figure out a way to strip out the actual email address from what they produce.
Well, they're actually trying to strip it all out. PST file, everything. Here's the takeaway in my mind. Mills gets a heads up, Cheryl Mills gets a heads up in midsummer of 2014. July 23rd, the day before Mr. Combetta's Reddit post, the Benghazi Committee and the State Department reach an agreement on production of documents. Cheryl Mills has a conversation with Paul Combetta. He goes on Reddit then and tries to figure out how he can get rid of all this email. Even though he's not successful then, he has to do it later down the road with BleachBit. And then the clincher. The clincher. Just last week, he's going online and trying to delete these Reddit posts. He's trying to cover up his tracks. He's trying to cover up the cover-up. So I guess the question is, and someone's asked it earlier, in light of all this, are you thinking about reopening the investigation?
I may have misunderstood what you said during the question. I don't understand that to be talking about deleting the emails. I understand to be talking about removing from the from line the actual email address. But anyhow, maybe I misunderstood you. But
the same guy later took BleachBit and did delete emails.
Sure. Yeah.
So my question is, the guy you gave immunity to, the guy who took the fifth in front of us, is online trying to figure out how to remove email addresses, change evidence, later uses BleachBit, that guy, who won't testify in front of Congress, and he has correspondence with Cheryl Mills, a subject of the investigation, Cheryl Mills, who also got some kind of immunity agreement, Cheryl Mills, who walked out for part of the questions during the interview with the FBI. Seems to me that's pretty compelling, and the timeline's pretty compelling as well.
Thank you, Mr. Chairman. Director, I've got a lot of concerns, but one of them refers to Reddit. At the time that the Department of Justice, at your behest or your involvement, gave Paul Gambetta immunity. Did you do so knowing about all of the posts he had on Reddit and capturing all of those posts and correspondence where he was asking how to wipe or completely erase on behalf of a VVIP, so to speak?
I'm not sure sitting here. My recollection is, and I'll check this and fix it if I'm wrong, that we had some awareness of the Reddit posts. I don't know whether our folks had read them all or not. We had a pretty good understanding of what we thought he had done, but that's my best recollection.
Okay. In the last week, en masse, he's been deleting them from Reddit posts. Is that consistent with preserving evidence? And I say that because there's still an ongoing interest by Congress, and only in spite of Reddit's own senior, what they call flak team, trying to hide it, only because a few people caught it, do we even know about it, and is this and other committees interested in getting the backups that may exist on these deletions? I guess my question to you is he destroying evidence relevant to congressional inquiries? And I'll answer it for you, yes, he is. And what are you going to do about it?
That's not something I can comment on.
Well, let me go into something that concerns this body in a very specific way. As a former chairman issuing subpoenas, I issued a subpoena, and additionally I issued preserved letters. In addition to that, now Chairman Chaffetz issued what were effectively preserved letters. Some of them were directly to Hillary Rodham Clinton while she was still secretary. Others, the subpoena in 2013 was to Secretary Kerry. These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay. For the record, yes, the Department of Justice does not grant immunity without checking with federal law enforcement to see whether it will impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were handing out like candy, according to some, immunity. Did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Gambetta. You gave them immunity from destruction.
Yeah, I don't.
2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records. And yet you say there is insufficient evidence of intent. You say she was extremely careless. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.
The chair recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Director, in your opening comments, you said this was an unusual case. I would say that's the understatement of the year. Husband of the subject meets with the Attorney General 3 days before Secretary Clinton is interviewed by the FBI. 9 people get to sit in with Secretary Clinton during that interview. One of those was her Chief of Staff, Cheryl Mills, who was the subject of the investigation. 5 people get some kind of immunity. 5 people get some kind of immunity, yet no one is prosecuted. 3 of those people who get immunity take the 5th in front of Congress, and one of them doesn't even bother to show up when he's subpoenaed. Supposed to have been at that very chair you're sitting at. And of course, the Attorney General announces that she's going to follow your recommendations, even though she doesn't know what those recommendations are, the only time she's ever done that. So of course this was unusual. We've never seen anything like this, which sort of brings me to the post. I'd like to put up the post that some have talked about.
Senator Cruz.
Thank you.
Thank you, Mr. Chairman. Director Comey, welcome. Thank you for your service. Thank you for your testimony. I have to say I found your answer to Senator Kennedy a few minutes ago puzzling, in that you described the reason why the case was closed against Ms. Abedin as that you could not determine she was aware her conduct was unlawful. And the reason that answer is puzzling is you're a very accomplished lawyer, and as you're well aware, every first-year law student learns in criminal law that ignorance of the law is no excuse, and that mens rea does not require knowledge that conduct is unlawful. And in fact, the governing statutes, 18 U.S.C. 793F and 18 U.S.C. 798A, have no requirement of a knowledge of unlawful. 798A provides whoever knowingly and willfully communicates, furnishes, transmits, or otherwise makes available to an unauthorized person classified information shall be fined under this title or imprisoned not more than 10 years or both. Under the terms of that statute, the fact pattern you described in this hearing seems to fit that statute directly, in that, if I understand you correctly, you said Ms. Abedin forwarded hundreds or thousands of classified emails to her husband on a non-government, non-classified computer. How does that conduct not directly violate that statute?
2013, a month before admitting to the targeting, Lois Lerner reminds colleagues to be cautious about what we say in emails. And on that same day, asks whether the internal instant messaging system is archived. When told no, Lerner responds, perfect. So back to May 2013. The IRS just admitted to targeting and the president just promised cooperation. Lois Lerner comes before Congress and takes the 5th. And on the exact same day, nearly 2 years after Congress started asking questions, the IRS finally issues a non-destruct order to all IRS personnel. So with an admission of targeting, subpoenas, and investigations underway, we return to the president's peculiar comments from February 2014.
Not even a smidgen of corruption.
Well, on the same day the president makes those comments.
As you are aware, last week I met with Director Comey and career prosecutors and agents who conducted that investigation. I received and accepted their unanimous recommendation that the thorough, year-long investigation be closed and no charges be brought against any individuals within the scope of the investigation. And while I understand that this investigation has generated significant public interest, as Attorney General, it would be inappropriate for me to comment further on the underlying facts of the investigation or the legal basis for the team's recommendation.
Secretary Clinton stated that she never sent or received information marked as classified on her server. Director Comey stated that was not true. Do you agree with Director Comey?
You know, Director Comey has chosen to provide great detail into the basis for his recommendations that were ultimately provided to me. He's chosen to provide detailed statements, and I would refer you to those statements. I, as Attorney General, am not able to provide any further comment on the facts or the substance of the investigation.
Well, General Lynch, I think you would agree that the ultimate responsibility for a prosecutorial decision does not rest with the Federal Bureau of Investigation, but with the Department of Justice, which you head. Have you not taken a close look at the work done by Director Comey, especially given the extreme national interest in this issue, to make a determination yourself whether you and those working for you agree or disagree with Director Comey?
As I've indicated, I received the recommendation of the team, and that team was composed of prosecutors and agents. It was a unanimous recommendation as to how to resolve the investigation and to what the information that they had received.
Do you agree with the conclusion?
And I accepted that recommendation. I saw no reason not to accept it, and again, I reiterate my pride and faith in their work.
Secretary Clinton stated that she did not email any classified material, and Director Comey stated there was classified material emailed. Do you agree with Director Comey's conclusion about that?
Again, I would have to refer you to Director Comey's statements for the basis for his recommendation.
Director Comey stated that there is evidence of potential violations of the statutes regarding the handling of classified information. Do you agree with Director Comey's statement?
Again, I would refer you to Director Comey for any further explanation as to the basis for his recommendations. The recommendation that I received from the team, including Director Comey, was that the investigation be resolved without charges.
Director Comey made a recommendation, but he made a recommendation to the Department of Justice, which you head, and you would have to come to the final conclusion on whether or not to act. I would presume that before you acted, you would look at his conclusions and determine whether you agreed with them or not. Is intent to violate the law a requirement under 18 U.S.C. Section 793F?
Well, Congressman, I think the statutes that were considered here speak for themselves. To answer further would require a discussion of the facts and the analysis of this matter, which, as I've indicated, I'm not in a position to provide at this time. Again, I'd refer you to Director Comey's discussion for that. As I've indicated, the team reviewed this matter, and it was a unanimous team decision.
And you made a decision following their recommendation to you that you were not going to prosecute and the matter was closed. Is that correct?
I made the decision some time ago that I would accept the recommendation of that team and was awaiting that recommendation. When I received it, there was no basis not to accept it. And again, I reiterate my pride and faith in them.
Well, thank you. I appreciate your faith in them. The concern here is regard to your sworn oath to uphold the United States Constitution and the laws thereunder, including 18 U.S.C. Section 793F and 18 U.S.C. Section 1924, and to conclude that no prosecution would take place without examining and drawing conclusions regarding the questions that I've just asked does not seem to be a responsible way to uphold your constitutionally sworn oath.
Words. Now, secondly, the misdemeanor statute does not require intent. It's a strict liability statute, and it relates to the removal and retention of classified information. So it doesn't matter whether Secretary Clinton had the intent to do that or not. The fact is that the FBI said that she did it. Now, I think that what Director Comey has said is that Secretary Clinton's actions essentially meet the definition for prosecution under the statute. Why did you defer to Director Comey when the responsibility is yours?
Thank you, Congressman, for the question. Let me be clear that my decision was to accept the recommendation of the team of agents and investigators who worked on this. And these are the career attorneys as well as the dedicated investigators, including the FBI director, who worked on this matter for over a year. They've reviewed the facts, they've followed the facts, they looked at the law, they've applied the facts to that law, and came up with a unanimous recommendation, a joint recommendation, in effect, that was provided to me.
I have a limited amount of time. One of the service people who was prosecuted basically sent an email out that his fellow Marines were in danger. And he ended up getting prosecuted for warning his fellow Marines that their lives may be in danger. Now, here in the case of Mrs. Clinton, the private email arrangement was simply to avoid public scrutiny. So in terms of the intent of Major Jason Bresler and Secretary Clinton, one, Major Bresler, was doing it to save his colleagues. The other, Secretary Clinton, was to avoid transparency. Now, in terms of the bottom line, that's the hoop that you have to jump through in order to retain and regain your credibility with the American public. I hope that you'll be able to do that. Now yield back.
You're not going to acknowledge what I think virtually every other American believes, even her supporters. And that's at least acknowledge, as Director Comey did, that she lied. Would you respond?
Congressman, with respect to the Director's statements, as I've indicated, he's provided really unprecedented access into his views of the matter, and I would refer you to them.
I, for the life of me, don't know what the difference between extreme carelessness and gross negligence is. He said he found one, but apparently not the others. Could you shed some light for me and perhaps anybody else in this room or that may ultimately watch this? What is the difference between the two?
Well, Congressman, again, I'm not going to further explain the Director's comments as he has, I believe, explained them.
Every American, including the President of the United States, including a candidate for the highest office in our land, ought to be treated equally under the law. And I think in this case, I think it's a travesty because I don't think Hillary Clinton has been treated like any other American would have been treated under the same circumstances.
So far today, you have rarely said absolutely yes or absolutely no, correct? You've mostly talked in terms of I can't answer that, or it's not appropriate, or see the FBI director. And so in light of that, and this is really a question of what do I tell the Marines, the sailors, Army personnel in my district, the veterans, the contractors, all those who work for the government with classified information. The former Secretary of State, in an unambiguous way, said repeatedly, both under oath and to the public, time and time again, I did not send or receive any information marked classified. And you're aware of that she had definitively said this repeatedly, right?
I believe her statements are on the record, and I defer you to that.
What do I say when, in fact, saying something that isn't true, handling classified information in an extremely careless way, has no criminal ramifications? What do I say to them? How do I reconcile the fact that they know that their friends and colleagues have been prosecuted or fired for doing less in the past?
Congressman, I can't speak to any cases you may be referring to involving friends or colleagues. Again, I would refer you to the description that
I appreciate
provided
that,
about
Madam General.
Or is that just a choice that you make in not disclosing that information?
Well, as indicated, we obviously are not allowed to discuss certain types of information, for example, grand jury information, in any
we're
matter.
Not talking about grand jury information here, are we? What I want to know is, tell me, is there a legal reason that prohibits you from giving us information, or is that just a choice you have made?
Congressman, as I've indicated, the Director and I had very different roles in this investigation, so his level of detail is significantly different from mine, and I would not be able to provide you with that same level of detail.
Because you don't have the information, not because there's a legal prohibition.
In addition to that, in part of my role as Attorney General, I would not be going into these discussions typically. We have taken the step of providing more information on this matter than in others.
I just need to know if there's a legal prohibition that prohibits you from disclosing information to this committee, or is that a choice you have made?
It would depend upon the nature of the information.
Questions
Certainly
that you've
there
been
would
asked
be.
that you've had, is there any legal prohibition that would prohibit you from giving the same information that Director Comey has given?
Well, with respect to the source of that information, if it came from the grand jury, that would be a legal prohibition. With respect to opinions
let the record say
about
that
the
there
matter
is
of
no
law,
legal
that's a different issue.
prohibition that can be cited here. Having looked at what the Supreme Court has now said, do you believe that prosecution was a mistake?
Certainly, I believe that the prosecutors who worked on that matter investigated it, presented it to a grand jury, and received an indictment. We, of course, have, as presented in our papers before the Supreme Court,
a choice which you
have
have
made a
not
different
made in
argument.
Secretary Clinton's case. It would be, can you tell us now, looking at that and the way you interpreted that statute, was that a mistake?
Congressman, with respect to the investigation of the former governor of Virginia, I don't have a comment on that. We have accepted the results of the Supreme Court.
Not because you don't have a legal prohibition,
and will, of course, be reviewing the case in the light of that.
Then my final question, then, as time is running out, is when you look at a governor of Virginia that you launched everything this department had against to destroy him and to prosecute him, can you tell me the federal nexus you had in that case and compare that to the federal nexus against Secretary Clinton in national security of this country, which you refused to bring to a grand jury or for indictment to see if, in fact, one is justified?
Congressman, I don't have a comment on the McDonald case except to refer you to the pleadings in that
Can you
for a
compare the
discussion of the
federal
law
nexus
there.
between the two cases for us, please?
Congressman, I don't have a comparison between those two cases for you.
And that's rather disappointing because the national security of the country is rather important to the country.
Do you believe that Hillary Clinton knowingly removed classified information?
I don't have a comment on or a characterization.
I understand that, and also you believe that she had intent to keep unauthorized information in an unauthorized location, and you have no comment on that?
No, I'd refer you to my statement on the recommendations that I accepted.
And I understand that. Now, the hinge of this thing, and according to Mr. Sensenbrenner, and I'll say myself, the definition of the word gross negligence, in that Director Comey used the term extreme carelessness, and Mr. Sensenbrenner asked you to define the difference between that and gross negligence. Do you find it ironic that the last examination of a Clinton in this room, the previous one, Bill Clinton, before this Judiciary Committee, not technically in this room, hinged on the meaning of the word is? It looks to me like this investigation is hinging upon the meaning of extreme carelessness versus gross negligence. Do you actually see that there's a difference between those two words?
Congressman, I always start with the statute, with any review that is being done on any matter by the Department of Justice. And we look to the statute, legislative history, case law, and we look at the facts as they're developed by an investigation and apply them to that statute and to that standard. And that is what the team did in this case, and that was, I believe, the basis for their recommendation. Director clear was that I would be speaking and meeting with the team who had done that substantive in-depth work for over a year, that had worked on this matter, that had compared the facts and the evidence.
Now, you've said that several times, Attorney General, and I don't have enough time to have you keep repeating that 4 more times. But when Chairman Goodlatte asked you about the statute and whether it includes the term gross negligence, you made an improper statement. You said discussion of the statute would require discussion of the facts. That's not true. You know, from my years of judging on the bench, your comment that discussion of the statute would require discussion of the facts, when he asked you about an element that's contained in the statute, Attorney General, that really sounds like an answer somebody would give who hadn't read the statute and was looking for a dodge to avoid talking about a statute with which they're not familiar. You are aware, and this doesn't require any discussion of any facts whatsoever, but you are aware that in 18 U.S.C. 793F, gross negligence is an element of the offense, are you not?
Congressman, I refer you to my statement that you just commented on with respect to
Okay, well, if you're not going to answer the question, I'm afraid you may be reinforcing it.
Question to me was the meaning of a phrase
Now,
in
you
the
said there was no basis not to
manner.
accept the recommendation of our team, but you've given no indication whatsoever that you did any independent reading of the evidence, of the statements. Was Hillary Clinton's statement even recorded?
Congressman, I'm not going to discuss the specifics of that. I believe the FBI has provided extraordinary clarity and insight into that.
Okay, well, if you're not going to answer the question, then let's move on. But I find it extraordinary that after a 3.5-hour interview, so quickly a recommendation is made. So there are inquiring minds that are very intelligent that have said, wow, I thought it would be weeks before an answer could be made, but it looks like to do a 3.5-hour interview, you haven't reviewed the facts, you reviewed the team recommendation, and I would just encourage you, Attorney General, your oath was not to follow the recommendation of some team. Your oath is your own responsibility to our Constitution and those that are working under you.
General Lynch, we are now about halfway through the members of this committee asking questions, and your refusal to answer questions regarding one of the most important investigations of someone who seeks to serve in the highest office in this land is an abdication of your responsibility. This is a very important issue of whether or not the Justice Department is going to uphold the rule of law in this country, and I hope that with the questions that will be forthcoming now, you will be more forthcoming with answers. Thank you. The gentleman is recognized.
Thank you, Mr. Chairman. General Lynch, who made the decision that no charges would be brought against Secretary Clinton?
Congressman, with respect to that decision, I had determined that I would accept the recommendation of the team.
So
I made that known.
Who ultimately made the decision?
I made that known, and then when the recommendation was given to me, I did accept that recommendation.
So did you ultimately make that decision, or did Director Comey?
Well, Director Comey was part of the team.
Who ultimately made the decision?
So the team consisted of prosecutors and agents. That did include Director Comey,
I want
but
to know
there
where
were
the buck
others.
stops. Who made the decision?
As I indicated before, I had previously decided that I would accept their recommendation when they made it to me.
Are you saying you made the decision?
Their recommendation.
Are you saying you made the decision?
I had previously indicated I would accept their recommendation.
Okay, so on July 1st, let's just run through that. On July 1st, you said, I'll accept the recommendations of the FBI. Mr. Comey didn't announce his decision until July 5th, and he said that he didn't talk to you beforehand. Now, I assume it's not unusual for the Attorney General to accept the recommendations of the FBI and the career prosecutors and the team, as you've so often cited. What is unusual is to make a big, bold public announcement that you're going to do it. It's one thing to do it. I assume it happens all the time. It's another thing to announce ahead of time you're going to do it. So here's what I'm having trouble with, and I guess a lot of people are having trouble with. If you commit and announce that you will abide by the FBI's decision before they even finish their investigation, then how can you also say ultimately it was your decision?
Well, Congressman, as I've indicated, I accepted their recommendation. I had indicated.
So are you, what I want to know is, was it not your decision or was it your decision? Because it seems to me you can't have it both ways. You can't say, I'm the Attorney General and I decide, but yet I'm going to take their recommendations even before they make their recommendations.
I had indicated that I would be accepting their recommendation because I wanted to make it clear that any conversation that I might have had with the former president would have no impact on the team or the review or the investigation.
You ever do this before?
I have not had occasion to do that before, but I felt it was important.
So you've never announced before an investigation is done that whatever they come up with, maybe they're going to screw it up, who knows? You've never announced before that whatever they recommend, I'm going to follow. Never happened before.
It was important in this case to do so.
So this is the first time you've ever done that. Announced beforehand, I don't care what their recommendations are, I'm going to, by golly, I'm going to follow them.
I have complete faith in the judgment and the hard work of the team.
I'm not questioning whether you have faith in them. I think probably a lot of people have faith in the FBI in a lot of situations. I don't know that they agree with them here, but I think they have faith in a lot of times. What I'm questioning is why announce ahead of time? When you've never done it before, why announce ahead of time, I'm going to follow their recommendations, even though I don't know what they are, and still claim you're the ultimate decider?
Well, as I indicated, I felt it was important to express my role in the investigation, to clarify my role, because I was concerned that the conversation I had with the former president would make people think that there could be some influence.
So that was the trigger?
That, in my view, was something that needed to be clarified. I felt that people needed to understand my role.
So you've never done this before, but when you have a conversation with the former president, the husband of the subject of an ongoing investigation, and you have that conversation before they've interviewed the subject and before they've reached their recommendations and finished their investigation, that's what triggered you to do this thing you've never done before, which is announce, I don't care what they recommend, I'm going to follow it.
My concern was that the conversation that I had with President Clinton would be seen by some as having an influence over that. I felt it was important to clarify.
Just some, General Lynch, a lot of people.
And I felt it was important to clarify that even before I had landed in Phoenix, I made that decision.
Here's what I see
felt it was
here.
important that people hear that from me.
Here's what I think is, I think your actions made it worse. I really do. I think a lot of people already think that there are two systems, as many have talked about, one for we the people, a different one, entirely different one for the politically connected. Your former Secretary of State, your former Senator, your former First Lady, your nominee for President, your husband meets with you 5 days before a decision is announced. Different standard for those facts. And you proved it. You demonstrated that it's different by your actions because you said you've never done this before, so you not only you changed your internal practices, you changed the fact that you've never announced beforehand that you're going to follow recommendations before you even have the recommendations. Your actions contributed to this belief that the system is rigged. And that, you made a bad situation worse by saying, I'm going to do whatever they recommend, even though I don't know what the recommendations are. I don't know anyone who would conduct themselves that way when they're the ultimate decider. But you said, I'm going to wait. I'm going to do whatever they said, and I'm not even going to wait to see what they're recommending. I'm going to follow it. You showed that this case was different, and the law is supposed to treat every single person the same. And your announcement, by definition, made this thing entirely different. And then, of course, what was ultimately decided made it entirely different as well.
Does an individual need a security clearance to review or have access to classified material?
Congressman, that issue would be dependent upon the agency for whom they worked and the nature of the work that they did. With respect
Can you give me
to
an example where you don't need a security clearance to view classified material?
No, I believe, as I was going to say, they would, but the type of clearance varies with every agency, and the agency would make that decision and determination.
Is it legal or illegal to share classified information with somebody who doesn't have a security clearance?
Congressman, it depends on the facts of every situation. You'd have to determine how that sharing occurred. You'd have to determine the means. You'd have to determine, the reason, the intent. Certainly, depending upon how you view the statute, it could go any number of ways.
Do you think there is a scenario in which you could share classified information with somebody who doesn't have the requisite security clearance?
No, I would not draw that conclusion. I would say that I'm not able to answer it as a hypothetical, but that there are a number of factors that would go into the decision, and one could have any number of results.
Is it legal or illegal to provide access to somebody who doesn't have the requisite security clearance to view classified material?
To provide access?
Yeah.
Again, I'd need more facts on the hypothetical, but I would look at a number of things, and depending upon how you reviewed it, it could go any number of ways.
Is it legal or illegal to store, house, or retain classified information in a non-secure location?
Again, I would refer you to the statute. One could, in fact, have liability, again, depending upon the nature and facts and circumstances.
Do you have any examples of where it's legally acceptable to retain classified information in a non-secure location?
I don't have a hypothetical answer for that.
Is it legal or illegal to provide false testimony under oath?
There are a number of statutes that cover that, both at the federal and state level. There are a number of ways in which that could be found.
There's a difference between prosecuting something and whether it's legal or illegal. You know, these questions are pretty simple, and we've got millions of people with security clearance. How are they supposed to go through the gyrations that you've laid out in order to make a simple determination?
Congressman, if we had a specific fact situation or fact pattern, that could be reviewed.
I'm just asking,
when it comes to a hypothetical situation, it would be unfair to come up with a blanket answer to someone without reviewing all the facts of their situation.
I'm asking if it's legal or illegal to share classified information with somebody who doesn't have a security clearance.
Again, I would refer you to the appropriate statutes, and I'd refer you to the facts of every situation. It would be unfair to give a blanket answer to every hypothetical.
Why aren't we telling all the federal employees and contractors who have access to classified information, those in our military, why aren't we telling them, you can't do this, it's against the law? Why can't you say that?
We give them guidance. Again, every agency does. We give them examples. We give them information as to how to make those decisions. We show them. And again, every information
why is the law not sufficient guidance? You believe Is there a flaw in the law? Or is there a suggestion on the law? I mean,
I don't have a comment on the state of the law. My answer is that in order,
somebody asked me to consult an attorney, and you are the Attorney General. And I think you're sending a terrible message to the world, to those people who are trying to make some simple decisions. The lack of clarity that you give to this body, the lack of clarity on this issue is pretty stunning.
And use your USDOJ.gov account to send classified information, do you?
we have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate, dedicated system to handle classified information. Why?
We have a separate system to handle the security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information?
That is the practice that I've certainly always followed. It
But
allows
it's not
for the
just
protection.
it's not just a personal preference, is
No,
it?
it allows for the protection of the information, both on a regular system, because again, that's still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
So let me, again, as I've indicated before, and I want to make it clear that, as I indicated before, while the reason why I would not be going into the analysis that was provided and the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why
that.
I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute
All right,
to determine whether
but
the
my
elements
specific
had been
question
met.
to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think public perception in a single-track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the Department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body alike, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
Let me ask you
particularly when
this.
charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
With all due
kind
respect,
of
Madam
political
Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the Department or personally?
No, just as a prosecutor. There's involuntary manslaughter, there's reckless homicide, there's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
Well, I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic, quite frankly.
I happen to disagree with Director Comey's conclusion, but I have a great deal of respect for him. I have seen him to be nothing but an honorable man, and reasonable minds can disagree. So I just have some questions that are similar to what has been asked before, but a little bit different. Director Comey said repeatedly that Secretary Clinton and her colleagues were, quote, extremely careless in their handling of very sensitive, highly classified information. Do you agree with this assessment?
I don't have a characterization of their actions. Typically, we do not characterize the actions of individuals. That was Director Comey's assessment of that, and my review
So you don't accept his assessment, but you only accept his recommendation to not charge.
As I said before, I did not come to a characterization or a description, as he did, of individual behavior. My discussion was focused on the investigation, what it revealed, and how it applied to the legal standards.
So Secretary Clinton had a security clearance while she was serving at the State Department, correct?
As far as I know, that is correct.
If any other federal employee with a security clearance is extremely careless with classified information, in your opinion, what would happen to that person's clearance?
I believe the matter would be reviewed and investigated, and the appropriate actions would be taken.
And in fact, Director Comey suggested if Secretary Clinton were anyone else, the facts uncovered in the FBI investigation could have cost her that security clearance. Is that correct?
I don't want to characterize the director's statements or testimony. I'd have to look at those.
But anybody else who would have been extremely careless with their security information, they would have lost their security clearance, correct?
I think the matter would have to be reviewed and handled according to the rules of the relevant agency.
In your experience as a federal prosecutor, if any other American with a security clearance had acted extremely carelessly with classified information, what would DOJ's position be on prosecuting that person?
Well, with respect to whether or not a prosecution would ensue, the issue would be the same as here, whether or not the evidence rose to the legal standard of all the statutes that were considered.
But you would seriously look at that, correct?
It would be the same consideration that was done here, but it would have to, again, reflect all of the relevant facts and not just a characterization of that. And again, I did not make a characterization or conclusion about that.
No, but if your characterization would have been that somebody acted extremely carelessly, what if that individual transacted business on Gmail?
As I said before, I don't have a characterization or description
I'm not asking for
of
your
anyone.
I'm not asking for that.
My only
I'm saying
point, sir,
if you would have found just a regular person working at DOJ extremely carelessly handling classified information on Gmail.
My only point, sir, is that the legal standard would have to be met.
Okay.
And you'd have to look at the relevant statutes regarding that person's information and how it was transmitted.
So was Director Comey
and the
correct?
Characterization or description
You've said
does
that.
not go to that.
Was Director Comey correct in stating that the range of punishment is from reprimand to termination to a possible criminal prosecution when someone is found to have mishandled classified information?
Certainly, if he was speaking about the steps that the FBI would possibly take, I would certainly reflect. I believe he would be reflecting his agency's own understanding of that.
Has the department ever reprimanded, terminated, or prosecuted an employee for mishandling classified information?
I'm not at liberty to go into that. We don't discuss individual matters here.
So you haven't. This would be a public record if you have prosecuted somebody.
It would be a public record. I don't have that information now for you.
And you have not reprimanded or terminated anybody who has mishandled classified information?
I don't know the answer to that information. I'm happy to have our staff speak and provide you whatever information we can, consistent with DOJ policy and the law.
So if a low-level DOJ attorney or FBI agent was reprimanded for carelessness with classified information, would that person have any chance of being promoted or otherwise advancing in their career?
You know, Congressman, I can't speak to a hypothetical. I also, again, would urge caution with using a characterization or description instead of a legal analysis.
You want us to respect Director Comey's conclusion but not his word?
You have to look at the facts in every situation.
I'm sorry. I'm actually confused by your statement. You want us to respect his conclusion, which I do, even though I disagree with it, but you don't want us to respect his words or to actually take any kind of statement that he made at face value. Is that what you're saying?
My answer is that, as I said before, a characterization or description is not the issue. It was a relevant legal standard reached. In every case, you would look at the relevant legal statute and you would see if the determination had been made that, in fact, those elements had been met.
If one of your employees carelessly used information, whether you would advance them in their career or not?
We look at every case and all the situation, all the facts and all the issues. We apply the rules and we come to a decision of determination there, consistent with the rules of our organization, as I believe any other organization would.
General Lynch, are federal employees generally prohibited from removing classified materials from secure area or network and placing it on open or unclassified networks?
Congressman, generally speaking,
it's a yes
the
or no.
issue that you're talking about, it would be covered by statute and regulation.
But they're not allowed to do that.
And it would prohibit the behavior that you're talking about.
All right, and are people allowed to retain classified documents in an unclassified environment?
Generally, no.
All right, so let me ask you a question. I'm going to get back to Ms. Clinton for a second. How did this information wind up on her server? I doubt Mrs. Clinton was technically savvy enough to copy it to a thumb drive and move it from one to the other, didn't have the patience to retype it. So obviously some other people took it off classified network and sent it to her. You think those people should be prosecuted?
Well, Congressman, with respect to any of the individuals considered in the investigation, as I indicated, I won't be going into the discussions about them. And as I've indicated earlier, and I said I know that this is a frustrating exercise for you. It is because
it is, and it's pretty clear you're not going to answer
we
my
asked the
questions
team
on it. So
to provide information
I
in a
have
confidential manner so that it can be reviewed without their being influenced by any political overtones.
All right, well, it's pretty clear you're not going to answer any of my questions.
The former president then spoke at length about his grandchildren.
So y'all didn't speak at all about anything pending, any pending investigations or Mrs. Clinton's problems with the email or the Clinton Foundation or anything like that. None of that was discussed.
If I could continue with what was discussed.
No, I'm just asking if you to discuss something that might be relevant.
We did not discuss anything about a case or matter before the Department of Justice. We did not discuss Mrs. Clinton in any way. He spoke about his grandchildren at length.
Okay.
He spoke about his
apologize
travels.
for interrupting you. I've
spoke
only
about
got 5 minutes.
what he'd done in
you've
Phoenix.
been very good at burning up the time and stonewalling. Should the President replace an Attorney General if the Attorney General does not enforce the law evenly, or should there be separate enforcement for different classes? And that's Stuart from Luling.
Congressman, there's no separate method of enforcement for anyone here. And as I said before, while I understand the frustration of people who disagree with the decision, I will say that it is similar to the frustration I have encountered when I, as a prosecutor, or others who are prosecutors, have to explain to someone why charges are not being brought, if their family member is involved, and the like. And so I understand the emotion that things generate. I understand the frustration that it generates. But it is something that we take very seriously. And as I said before, we follow the law, we follow the facts in every single case.
Director Comey said that the Department of Justice has grave concerns about whether it's appropriate to prosecute somebody under a gross negligence standard. Do you, as the Attorney General, have grave concerns about prosecuting, forget about this case, anybody under a gross negligence standard?
Our concerns are always whether or not we have the facts to support
I'm not
the charge.
asking about the facts.
That is a concern
Assume
in
you
every
have the
case.
facts. Forget about this case. Do you have grave concerns about bringing a prosecution under gross negligence?
I would have to have the factual record before me.
Did any of the people who were on the team that advised you, did they tell Director Comey that they had grave concerns about bringing a case under a gross negligence standard?
Congressman, I wasn't privy to those
Because you guys
conversations,
prosecute
so I'm not able
environmental
to
crimes under
say.
a negligence standard, correct?
We do prosecute a
Those
number
are
of crimes.
constitutional prosecutions, right?
We do prosecute a
States
number of
across
crimes
the
under
country
different
prosecute
standards.
for homicide. You can have a negligent homicide. And so Director Comey said, well, look, people say you can do this, but how come there haven't been cases brought recently? How many cases has the Justice Department declined to bring under 18 U.S.C. Section 793F because they were concerned about the gross negligence standard?
Yeah, I don't have the answer to that.
Do you know if there's been any that have been declined over the last 10, 20 years?
I don't have the answer to that.
I'd like to get that, because I think that that's important, because you can say people haven't been prosecuted under it, but maybe people in the civilian sector have actually met their responsibilities by and large and not been extremely careless with it. I'm a little bit disappointed with how you've approached this. I think that given all the circumstances that are involved in this case, and again, I'm just talking about the appearance of what the average Joe sees. You yourself were appointed by President Clinton in the 90s to be U.S. Attorney. Your current boss has said on more than one occasion before Comey's recommendation that Hillary Clinton having top secret information on her email did not damage national security. You, of course, met with Bill Clinton privately just days before the decision was announced not to go ahead with this prosecution. Of course, your current boss has endorsed Secretary Clinton to be the next president of the United States, and in fact, they had a campaign trip scheduled, I believe, the afternoon that Director Comey announced his findings. And so with all of that surrounding, there's a lot of people that have concerns about whether this decision was made with proper integrity. And basically what you've told us today is, I'm not going to talk about it, I'm not going to justify it, it is what it is. And that falls very short, I think, of what a lot of people want. And I've noticed that you have been willing to opine on other instances when it suits you. I mean, for example, in Orlando in June, you said the most effective response to terror is compassion, it's unity, and it's love. You were interjecting on that. You said after the San Bernardino attack that your greatest fear was the rise of anti-Muslim rhetoric. That was something that you volunteered. You discussed the possibility in front of the Senate Judiciary Committee in March of bringing civil actions against people who denied climate change. And of course, you also discussed taking potential criminal action against those engaged in anti-Muslim speech. And so I want to ask you whether your hear no evil, see no evil performance today, if somebody honestly just looks at what happened here and thinks that if they were a junior officer in the Navy or a mid-level official in the federal bureaucracy and they treated classified information like this, that they would have been held accountable, and they look to see all these circumstances, and then here you are to justify as the head of the department, and you're offering them nothing. Do you understand that there's going to be a lot of people that are not satisfied with that?
Well, Congressman, as I've indicated, I understand that people are often frustrated when they don't either understand or have clarity into the reasons behind a decision. In this matter, there have been a number of times when unprecedented clarity has been provided. In terms of the FBI director's statements, for example, that was unusual clarity into his thinking and what led up to his recommendation.
It's also unusual for the Justice Department to be investigating somebody who's endorsed by the sitting president, though. I believe that's completely unprecedented. So there's a lot of things. The unprecedented nature of this can cut both ways.
During last week's oversight hearing, Chairman Chaffetz and Director Comey asked Director Comey about Secretary Clinton's granting her attorneys access to emails for the purpose of document review. Specifically, he asked, did Hillary Clinton give non-cleared people access to classified information? Director Comey responded, yes. My question is this: does the conscious decision on the part of Secretary Clinton to grant access to classified information to her attorneys who did not have security clearance constitute criminal intent under 18 U.S.C. Section 793D, which describes the intent element as the following: willfully communicates, delivers, transmits, or causes to be communicated, delivered, or transmitted, or attempts to communicate, deliver, transmit, or cause to be communicated, delivered, or transmitted to any person not entitled to receive it.
Congresswoman, I would need to have information about the recipients what information or what background they had, what clearances they had or didn't have, and I simply am not able to provide you with that answer because I don't have that full information.
So you do not know if her attorneys had security clearance?
I do not have that information.
My understanding is they did not.
And discussed here, but let me get you the exact citations.
I never thought I'd say this. I actually, and I say this with due respect, Attorney General, I miss Eric Holder. Because at least when he came here, he gave us answers. We didn't like it. But I've spent the last 4 hours listening to basically the Attorney General of the United States not willing to make a concrete statement of law. To not be willing to say that when given the opportunity by a colleague of mine, who made the decision in this case. I understand Director Comey stepped up and said, here's the decision we recommend. And y'all, you have been willing to say as well, we just accepted the team recognition. When given the opportunity to say, do you accept this decision, you've never answered directly that you own this decision. Do you own this decision?
Congressman, as I've stated, I made the decision, and I do accept. I did accept it, and therefore I made the decision to accept that recommendation. That was the action that I took.
The problem that we're having here, though, is you took a decision because you had to. Your own words just a few moments ago, that the meeting on the tarmac led you to do something. That was your exact words. It led me to do something, and that was basically recuse yourself, but didn't recuse yourself. You just said, I'm going to accept what they tell me.
It led me to discuss the decision I'd already made about how the matter would be.
Had you already had conversations with the team before you made this statement and before the meeting on the tarmac?
No. Before I had a conversation with former President Clinton, I had not spoken with the team. I had concluded in my mind how it should best be resolved because I had tremendous faith in their work and their integrity.
Did you have it as best be resolved as far as what they're doing and the way it was going about, or the end outcome?
I had no conversations about the end outcome of the investigation.
Do you believe that there is such a thing as a strict liability offense?
Depending upon the statute, environmental matters,
no,
for example,
we went to law school. Is there
OSHA,
strict liability offenses or not?
In OSHA, for example, there are.
That
in
a
some
yes or no?
environmental cases, there are.
Simply yes or no.
I've given you two examples.
No, I want a yes or a no. Is there strict liability
I've given
offenses?
you 2 examples.
I'm not. This is, again, the issue that we have here is there's no ownership at DOJ. It's no wonder the optics of this are so bad. I've never agreed probably with David Axelrod in my life, but the optics of this are terrible, and you today have made it worse. And as also a member of the military who just got through with my drill duty this weekend, you have basically, to me, offended every military member here who handles classified information, who does so with their training, and you've basically said, well, it depends on this. I got a question for you. Riding down the road, the speed limit says 55. I'm doing 65. Have I broke the law?
You'd have to ask the Highway Patrol.
Oh,
they would likely write you a ticket. They would likely write you a ticket for that.
I'm not sure. I went to a small little small law school. We taught the law. Harvard, I'm not sure anymore. Did you break the law or not? 65 and a 55. My dad was a state trooper. Be careful with your answer. You're under oath.
As I said before, you would get a ticket for that.
Okay, so you broke the law.
You would be cited for that. That would be considered an offense.
In this, just the amazingness of this, when you've been asked many times, you said, I'm not going to talk about this. The day after, you said, well, I'm just going to have to accept whatever they tell me because you're not going to do any investigation. You're not going to put the Attorney General, the top law enforcement officer's stamp of approval on it. You said, I'm just going to accept whatever they give me. Did you at least read anything before you had a press conference the next day? Did you at least look at the testimony from Hillary Clinton?
Well,
did you at least look at anything?
Time of the gentleman.
I did not hold a press
Time of the gentleman has
conference.
expired. The witness can answer the question.
Thank you, Mr. Chairman. I did not issue a press conference. I issued a statement. I did receive a briefing from the team. It was thorough. It discussed the findings that they had come to. It discussed the legal analysis that they had made. My decision was to accept those findings. And as I've said before, that was my decision.
As a famous leader once said, the buck stops with me. Please go read that. This has been depressing.
General Lynch, after your meeting with Bill Clinton, you were asked in an interview about the appearance of impropriety and said, no matter how I view it, I understand how people view it. It has now cast a shadow over how this case may be received. Do you remember saying that?
That was a few days afterwards in an interview. Yes, sir.
We know that you made the decision at that point not to recuse yourself from this investigation. 2 days after you made that statement about casting a shadow on the integrity of the Department of Justice, the New York Times reported that, quote, Democrats close to Mrs. Clinton say that she may decide to retain Ms. Lynch, the nation's first black woman, to be Attorney General, end quote. Did the timing of that, right after the Bill Clinton meeting, give rise to any thought in your mind of reconsidering whether or not recusal in the light of appearance of impropriety might be appropriate?
Congressman, I have no knowledge of the source of that statement, nor have I had any conversations about that.
Didn't give it any thought?
My view was that I needed to discuss the conversations I had with the former president to clarify my role in the investigation.
So I don't want to impugn your integrity by asking you whether the prospect of future employment as Attorney General in a Hillary Clinton administration influenced your decision whether or not to recuse yourself or influenced your final decision regarding prosecution. But now that you've already made that decision and closed the matter, will you consider serving as an Attorney General in the Hillary Clinton administration?
Congressman, my focus is on serving as Attorney General in this administration.
I don't care about your focus. What I want to know is, will you rule it out?
That is my focus now.
You won't rule it out.
It is working on the issues before the Department of Justice. That matter is not before me.
Well, I got to tell you, that shadow that you cast on the Department of Justice just got a whole lot bigger. Because if you're not willing to rule out future employment in the Hillary Clinton administration, what that means is the American people have every right to wonder whether or not you looked at this through a fair and impartial lens, because your answer tells the American people that after the FBI director told you that Ms. Clinton had been extremely careless with at least 110 emails marked as top secret, secret, or classified and may have jeopardized the lives of actual Americans, and told you that she made numerous false public statements about sending, receiving, or turning over classified materials, you might want to apply for a job with her? Your answer, not ruling out employment with her, means that as much of the free world is wondering whether or not Hillary Clinton should have been prosecuted and possibly sent to prison for being extremely careless, as the FBI director said, with hundreds of top secret, secret, and classified emails, you're telling the American people watching today that instead of going to jail, faced with the prospect of possible future employment, you think she should go to the other end of the spectrum and be eligible to be the person with greater access and greater control over America's most sensitive and trusted national security information than anyone else on the planet? I got to tell you, utter shock is an understatement with respect to what I just heard you say. So let me ask you this question.
Well, Congressman,
I want to ask you this way. My time is limited and the clock is moving. Based upon your unwillingness to rule out future employment, in light of the fact that you and your husband had a 30-minute conversation with the spouse of a pending federal investigation, of the subject or target of a pending federal investigation, and with a person who would be the subject or target of the federal investigation, if there is one into the Clinton Foundation, would you at least agree with me that if there is such an investigation, you'll have to recuse yourself from that one?
Congressman, with respect to other matters before this committee or any other, or before the Department of Justice, they'll be reviewed like any other. I will take all the appropriate action that I would need to take.
I'll take that as a no.
In that instance.
And let me move on.
And Congressman, as
I've
indicated to your colleague, just as I will not comment on the statements of candidates or candidacy of anyone,
I'm not going to let you run out the clock on the American people that have questions that need to be answered. So let me move on. On July 5th, one week after your meeting with Bill Clinton, FBI director made an unprecedented, extraordinary public recommendation not to indict. But his statement was just a recommendation. You've said, I made the decision. And in his statement to the press, he said that what that decision would include would be quote, considerations like the strength of evidence, especially regarding intent. He said also that a responsible decision would consider the context of a person's action. So my question to you is, as you made the decision, did your final decision weigh the strength of the evidence and the context of Hillary Clinton's actions?
I will tell you, Congressman, that that was part of what the team that was presenting to me was focused on, and it was certainly encompassed those issues as well as all of the other issues that I've indicated before that would be in that. It would be contained within their entire recommendation to me.
And that was reflected in your two-sentence statement about that starts out late this afternoon. I met with FBI Director Jim Comey and career prosecutors. By the way, how long did that meeting last?
Yeah, I don't recall.
Hours?
I don't recall, and I wouldn't be providing that information.
More than hours?
I don't recall and would not be providing that information.
It says late in the afternoon. I assume it was in one day?
It's clear from the statement when the meeting occurred.
Okay, so it happened the day after, and apparently within a matter of hours, if it happened in one day. So you just told us that after a year-long investigation involving 150 FBI agents working around the clock, involving more than 30,000 emails, tens of thousands of man-hours, that your thoughtful, careful weighing of strength of the evidence took you an afternoon, a cup of coffee with the FBI director, that your decision in this case for charges relating to a person who, according to the FBI director, said was extremely careless handling America's most sensitive national security matters and is seeking to be a candidate in charge of America's most sensitive national security matters, took the better part of an afternoon. It didn't last weeks, didn't last months, didn't take days. You weighed that evidence, determined her intent and gross negligence in a matter of hours. Will you at least tell the American people whether or not you at least reviewed the 110 top secret, secret, and classified emails that we know that she sent and received on an unsecure, unauthorized server? Will you at least answer that?
As I have indicated...
Time of the gentleman has expired. The witness is permitted to answer the question.
Thank you, Mr. Chairman. As I've indicated, I received a recommendation after a briefing from the team, which included the career lawyers as well as the FBI director. I received a full and thorough briefing. We reviewed and discussed the matter, and I accepted their recommendation. And as I've indicated earlier, again, just to be clear, the reason I do not go into these internal meetings is because the teams of prosecutors and agents who work on every matter need to be able to provide their full and unfettered advice, counsel, discussion, without the fear of political overtones, without the fear of that kind of
Since you didn't
influence.
answer that question, I'll give you a preview that I'll ask Director Comey that when he's in front of Homeland next week. And let me just close then, summarize by saying, so less than after a week after you met privately with the spouse of a target of a federal investigation, a target with whom you haven't ruled out applying for a job, you didn't recuse yourself and instead spent a grand total of a few hours reaching a decision regarding tens of thousands of documents involving our national security, and you can't seem to understand why the American people, Republicans, Democrats, and independents are outraged at your actions. If you thought the meeting that you had on the tarmac with Bill Clinton cast a shadow over the integrity of the Department of Justice, what I've heard today from you made the size of that shadow something that I will tell you that as far as casting shadows that the American people pay attention to, Punxsutawney Phil's got nothing on you.
Well, General Lynch, this concludes our hearing. I thank you for providing us with more than 4.5 hours of your time. However, scores of questions were posed to you that were not answered by you. Some you've offered to get back to us about in writing afterwards. We will be forwarding to you additional questions related to other matters raised, as well as the investigation and non-decision to prosecute former Secretary of State Clinton, and we would expect that you would answer those questions. You are the Chief Law Enforcement Officer of the United States, and you are the Chief Law Enforcement Officer of the United States, and the final decision regarding the prosecution is yours. And the fact that you were not able to provide us with answers regarding how that decision was reached is very concerning to members of this committee and to the American public.
Not even mass corruption, not even a smidgen of corruption.